Dear viewers, welcome to BW Legal World. I'm Asha Mauri, and we are in conversation today with a very erudite lawyer, a biker, a very warm personality, and a mentor come friend, Mr. Sameer Jain, Managing Partner, PSL Advocates and Solicitors. Hi Sameer, I welcome you on behalf of BW Legal World, and it's a pleasure to have you with us today.
Thank you, Shashma. Pleasure is shared.
So, Sameer, let me introduce you to the audience. You started the firm as Premises Law Chambers in the year 2012 with 4 partners. And in 2017, the firm was renamed as PSL Advocates and Solicitors to form a 7-partner and 25 associate strong Delhi and Mumbai practice. And in a very short amount of time, the firm is now recognized as Tier 1 in disputes arbitration by Legal 500, top tier in international arbitration, ranked firm in corporate and commercial, notable firm for tax laws, and also insolvency by Benchmark Litigation Asia Pacific 2020, among many other recognitions over the years. Where did this journey begin?
Quite an interesting question, Ashama. A lot of people ask me, did you always wanted to be a lawyer? As much as I want that question to be an affirmative, no, I did not. I was very attracted to technology and the cutting edge, computer science, which was going, and I'm talking about 2000, early 2000, 2003. And I was in Lucknow at that point of time, and as every student wants at that point of time, I wanted to be in IIT and do my computer engineering. And I finished my class 10th and class 11th and 12th. Somehow I realized that I probably can't sit for 22 hours a day and study. And I did not want to be in any other college but IIT. So I decided not to do engineering, and also rejected my dad's wish of becoming a doctor. And then, of course, I chose commerce stream, and then I did my +2 in commerce. That was the point of time when I really wanted to go to St. Stephen's or SRCC to do my econ honors. And my dad at that point of time said, son, why don't you try law? And my idea of law at that point of time was derived from my dad's position as a district court judge in UP, which, with all due respect, was not what I wanted for myself in life. So he knew what I really liked, and at that point of time in Lucknow High Court, I think there was a matter of patent of some technology, and my dad took me to the court, and Mr. Nariman was arguing. And I sat and I heard, and I was bewildered at the sheer eloquence with which he was explaining to the judge all about technology and all about the patents. And that was the day it sealed the deal. I said, Dad, I'll be a lawyer. And haven't looked back since then. I don't think at this point of time, if you ask me, I would want to do anything else but practice law.
That's great. I think we're glad to have you in the fraternity.
Likewise.
So that's quite an interesting turn of events. And, from deciding to being a lawyer, then you also worked with Goldman Sachs, E&Y, Luthra & Luthra before you started your own firm.
Yeah.
So how did that shift happen, like going independent?
So it was kind of a planned move. When I was in college, and I'm talking about 2007-8 when I graduated in 8, last 1 year was spent with friends discussing whether litigation is good or corporate law is good or investment banking. And I was at that point of time interning in Goldman Sachs, and that extended to the recruitment period in college. And 2008 meltdown had happened. My position in Goldman was confirmed, but in 2008 they came back just before I was about to graduate that we can't confirm your position, so look for a job elsewhere. That's when I decided that I will try and test everything. I worked in-house kind of at Goldman. I worked with Ernst& Young to get an experience of a consulting firm, and worked with Luthra & Luthra to see litigation and law firm. And that's when I decided that, litigation is my calling, and that's when I started my own firm.
That's nice. And correct me if I'm wrong, yours is a boutique law firm with a wide range of services, and your individual practice primarily focuses on international commercial arbitration, corporate and tax litigation, insolvency and bankruptcy, IP media and entertainment, so on and so forth.
Yes. So we've had a very slow progress. We were very conscious not to jump into and everything. However, at the same point of time, we were very conscious that with the passage of time, you have to keep on providing relevant services in the market. Disputes might sound as one broad area of law, but it practically encompasses within itself every other area of law. You can be a securities disputes lawyer, while you can be an IP lawyer, you can be an arbitration lawyer. So within the realm of dispute and general corporate advisory and tax, we started giving niche area of services in disputes. We also made a conscious call to be an association of litigators and not only solicitors. So we do most of our advocacy ourselves. Most of our partners, associates, senior associates go to the courts regularly. And that was a conscious call. Over the period of 2012 to 2020, 8 years, we slowly build up a practice. I was historically doing tax in EY and Luthra & Luthra. I still do a fair amount of tax as a standing counsel for CBIC. But I'm a kind of person who likes doing everything. So you can say I'm a jack of everything. And that's what I love about this profession. One day I'll be arguing an arbitration matter, another day it will be a testamentary, then criminal. So while the focus remains arbitration as such and corporate commercial disputes, but with enough preparation and enough material and brilliant colleagues around, I think we end up doing justice to every matter.
That's nice to know, Sameer. And so, like you said, so many practices and so much is happening in the IBC and arbitration and IP spaces. Let's narrow it down and let's take this one by one. What are your views on the insolvency and bankruptcy code?
Well, it's a very interesting new area from a practitioner's perspective. While it started as an alternative to winding up proceedings, it more or less also got focused on recoveries, because the procedure mentioned was very, very, very efficient. And initially, the time which was taken for a petition to get disposed of was very less. So people thought that, yes, why not during an undisputed debt go to NCLT? Now, though, I feel that unfortunately, NCLTs all across the country are also clogging up with the numbers of matters being filed. So while it still remains a good law in place, its implementation needs to be more efficient in terms of more number of courts, which I see that the government is constantly trying to, appoint more judges to the tribunal, appoint more judges to NCLT. The new NCLT building is absolutely fantastic. So all in all, it's a good show, I would say.
Okay, and what would you say about, if you could strike a, detail it for us in a way that what is happening on the corporate insolvency and also the fresh start process for individuals. So what's happening there?
So as far as the corporate insolvency is concerned, as you would be aware, there is a blanket hold on to any new matters in respect of debts, whichever is during the COVID period. I think that was a very smart move by the government, because as the situation has it, everyone in the industry is defaulting on one debt or the other. So to prevent companies from going to CRLP, they have increased the threshold, which was earlier 1 lakh, and also suspended the proceedings under section 7, 9, and 7, 8, and 9, 10. So while the corporate insolvency process, a new one is absolutely on hold right now, but the initiation proceedings, I think you need to understand, is that the initiation of corporate insolvency process is only 10% of the whole IBC litigation. The more complex litigation starts thereafter, when you have to either represent a client from the RP's perspective, the COC's perspective, the resolution applicant. So many interested parties immediately thereafter, once the petition gets admitted, that it gives a flavor to everyone involved. And it's heartening to see that more and more people, more and more great counsels and firms are coming in, establishing practices under insolvency laws. So I believe that corporate insolvency litigation is on a good run right now. As far as the fresh start process is concerned, I have my own concerns there. One, of course, it's yet to be brought in place, but it all depends upon the threshold, the eligibility of a person to apply in a fresh start process. I think the threshold is some 60,000 rupees per annum of income by a person. Now, I am at a loss to really explain that there would be people who would be falling in that bracket, but would those people be in a position to approach an NCLT to get their grievance or take benefit of the fresh start process? So I think that the whole threshold system needs to be reworked once the government actually thinks of implementing it.
And I think
otherwise,
it also
not any benefit. Sorry. Yes.
Yes. I think it also says something about having no dwelling units, or so.
A lot of things, and that's why I think that to make it more efficient and to achieve the purpose, you need to bring more people under the net, especially after COVID, especially how the government expanded the MSME threshold to include more and more companies under it. So if the government wants to do a fresh start process and see it working for the people who are relevant, not that's the wrong word, but people who actually need it, then the threshold needs to be increased a little bit, I think.
That's true. And when we were speaking offline, you mentioned many young graduates and lawyers have taken a shine to this practice. So what is your advice to lawyers wanting to establish practices in this space?
Well, my advice to younger lawyers is this, that the beauty of law is to do all what it offers you to do. I think before you get onto a particular area of law and zero down on a particular area of law, try and attempt to work in a lot of other areas, so that you know that what you thought was your calling in life in college, that remains the same. I say so because I, for one, did my honors in international trade law and WTO. Spent 5 years of my career doing tax, and then started doing arbitration. In the process, I dealt with so many other areas, and over the period of 8 years, that I know that where I want to specialize. It just may not serve everyone well to only decide in your fourth or the third or the fifth year of law school to think that I just want to do arbitration or I just want to do insolvency. Because things from outside are very rosy and very shiny. But what it actually entails to do that is very different. And I feel that unless and until you have experience of a lot of other things, you really can't do arbitration or insolvency, just that. Arbitration is a procedure, okay? It's an alternative dispute resolution mechanism. The law remains the law, applicable law of the contract, and you have to work on those areas in court-related disputes, in your domestic arbitration. You just can't say that, no, international arbitration is the only thing I want to do in life. That's a little myopic. I personally feel that you will be very well suited and very well placed if you spend the first 3, 4, 5 years doing everything and then decide what I want.
That's a very wise advice. And coming next to, again, arbitration.
Yeah.
So how close are we to becoming the hub of arbitration? And, like earlier arbitrations in India were plagued by court interference. And now we see the courts seem to have moved to the other side of the spectrum with little to no interference. Is that a good sign?
That's of course a very good sign, Ashima. At least where my majority practice lies in the Delhi High Court and the Supreme Court, it's heartening to see that judges really don't want to interfere with arbitral awards. They take the provision and the basis on which you can actually challenge an award to be very, very, very strongly. First to answer the court interference part, however, that attitude needs to spread to more courts. That attitude needs to spread to trial courts as well. Say, for example, state of Haryana, the pecuniary jurisdiction, and also in UP, the pecuniary jurisdiction of the courts is unlimited. So Rajasthan, UP, Haryana, so a 34 challenge to an arbitral award will always go to the trial court. It's very difficult for a judge to explain a judge that you are not sitting in an appeal, that your hands are tied, that you cannot look into the way an evidence has been appreciated, that you only have to look at the violation of the public policy of India and some limited grounds. So that attitude needs to change, which will change slowly and slowly. I'm very hopeful that at least majority of the high courts and trial courts will buckle up and not interfere with the awards. As far as India becoming a hub of arbitration is concerned, that is a question which has been asked to any and everyone for the past 5 years. We have seen a lot of developments in terms of MCIA being formed, in terms of the government taking very active interest in getting the ICADR, which is now the New Delhi International Arbitration Center, the Delhi High Court Arbitration Center. They are very, very efficiently working. But as far as infrastructure is concerned, is something which we need to look at. Either private players need to come in, set up brilliant arbitration hearing infrastructures, and also to have an Indian institution which gets up to the line and compete with the SIACs and the HKIACs of the world. Of course, it will take some time, but establishing them and managing them and making sure they're working with the same efficiency is the first step towards it. So I think infrastructure and institutions are two things which really, really need to improve in this country. And I know for a fact that steps towards that are being taken as we speak. So I wouldn't say it's a 1-year dream or a 2-year dream, but we should look at a 10-year span for India to be considered as a hub for arbitration.
All right, but what would you say about ODR in the, that's coming along to support ADR?
Online dispute resolution is a necessary alternative to physical hearings. No one can escape it. The situation which remains today, I think, will be in place for the next 7-8 months. You can't have your arbitrations hanging. As far as international arbitration is concerned, the community is well geared to have hearings internationally. In fact, 13th and 14th, I'm sitting as an arbitrator in an international arbitration with arbitrators from Dubai, from Germany, parties based in India and Germany. We had to be in Doha for a physical hearing, but we decided to do it online. And I will see how it actually goes. However, there have been mock hearings and it has worked flawlessly. So online dispute resolution is going on well. The technology needs to be updated. There are concerns of witness examination, witness tampering, because there's no one in front of you. Every tribunal is devising their own procedures to make sure that doesn't happen. But I think it's like any other evolution. The baby will grow up to become someone who can be trusted. So I think it's here to certainly stay.
That's nice. Fingers crossed. So So moving along, also speaking about IP and IP
Yeah.
laws and the social media trends these days, does India need to revamp its IP and copyright laws in view of the Instagram generation?
Ashima, I have a different view on that than what people have been saying globally and otherwise. I don't think we need to really revamp our laws. I think we need to make sure that the implementation becomes efficient. So is under criminal law. People will say that, we need to revamp our criminal laws to deter people from doing crimes. No, we don't. We already have provisions which cover most of the areas which are under dispute. I think the implementation is where the problem is. Having said that, the silver lining in the COVID situation has been that everyone within the system, be it the private side or the government side, have been working at very high efficiency. And because the mode of high efficiency is on, this is the time when major revamps in terms of implementation of laws can be done. A lot of other things will be taken care of when the data protection bill gets implemented. I think the parliamentary committee report is still due, and most of the European companies in India are anyways following the GDPR regulations. We just need to make sure that our data protection law and the GDPR and the global data protection, landscape kind of matches with each other. We don't want a law which is absolutely starkly different from what is happening globally, because then there'll be a lot of issues for multinational corporations to have a separate set of data protection laws in India and a separate set of data regulations for their holding or subsidiaries outside of India. So yeah, I think laws are very well in place. We just need to implement them better.
That's good. That's good to know that we don't have to do another exercise altogether.
Not required as of now.
Great. So, what would you say about the other live legal issues plaguing the industry currently, given our environment and what's happening there?
Well, I think the real pandemic right now is not COVID. The real pandemic is force majeure. I think since March till date, if you were to scan my inbox, 60% of the emails would be in relation to one or the other aspect of force majeure. So that's one area which really needs to get settled sooner than later. Because the jurisprudence on force majeure is extremely limited in India. It's not statutorily recognized. It's a creature of contract. And not many situations, luckily, have arisen in the past which would have led people to invoke force majeure. So there are very few judgments to that effect. Delhi High Court has come out with a couple of judgments on the force majeure aspect. So that's one aspect which is really plaguing the legal industry today. There are a couple of issues which are not related to COVID, but have been pending consideration of the Supreme Court. For example, arbitration under lease agreements. Landlord-tenant disputes will top the list of disputes which will be filed or under process during COVID. And to prevent courts from getting clogged with these landlord-tenant disputes, a lot of big leases already have an arbitration clause, but the whole concept of arbitrability of real estate disputes under the current Transfer of Property Act is pending consideration of larger bench. So if that gets decided soon, I think that will clear the way for alternative dispute resolution in these areas. Apart from that, I don't see any other major issue which is plaguing our system as of date. And these issues are also not plagues. These are issues which really needs to get settled for smoother, functioning of the justice delivery system. So I think we have been in a good space right now as a country.
Great. But what would be your advice to your clients when it comes to claiming force majeure? And what have you been telling your clients already?
Well, it depends upon who I'm advising. It depends on whether I need to claim force majeure or I need to avoid force majeure.
Yeah, that's true. So any tips there?
My only tip is read your contract very specifically. There is a very rampant misconception in the minds of people that just because the words force majeure appear in your contract, anything and everything is covered under those two words. People don't realize that merely having a force majeure term in the contract means nothing. It needs to be defined well. It needs to be followed to the T in terms of the contract. And your situation, which you're claiming, the COVID-19 situation, should actually be contemplated, not in the exact words of a pandemic or an epidemic, but even if there's a general sentiment in that clause which intends to cover a situation like this, needs to be there. So my only advice is, before raising a dispute or unnecessarily resisting a dispute or resisting a request for waiver, it's imperative that everyone reads their contracts. Well, I've been advising all my clients to, that right now is the time that the work is less. You have more time. So why not internally have a review of all your contracts, not only your real estate contracts, but all your supply contracts as well, because everything is getting impacted, so that you at least have a matrix prepared where you know what needs to be done when a dispute under the contract arises. So that's what I have been advising my clients on force majeure at least.
Thanks, Sameer. And interestingly, speaking about contract review, that brings another question to mind, that how has COVID-19 impacted the legal space in India? For instance, the boom of technology has been a very welcome change, of course. But how do you see, this will shape up our system? And what are your views on the legal tech and AI in the legal space? How far are we from replacing lawyers with AI? The routine contract work is, as we speak, in the West at least, has been taken over by legal tech.
Okay, so let me get the elephant out of the room first. I think no one is replacing lawyers. That scare needs to get out of people's mind. Technology is only there to assist, and it will assist. What would happen is that if you needed 10 people for a job, for reviewing documents, that can be done by 3 people, but that doesn't mean the rest 7 are irrelevant. It only means that you can now allocate your human resources in more wider aspects of your practice, rather than having them blocked on one assignment. So it's only assist us as lawyers to get better, to give more error-free advice, have a better review of documents. So in fact, we're probably one of the very few firms who recently took on artificial intelligence and machine learning based software and used it in one of our massive arbitrations to review around 10 lakh emails and some gigabytes of data. And at least I think we were able to save around 80% of the time which we would have taken in manually reviewing all of them. So yes, technology is a boon. COVID is forcing people to adopt technologies. How COVID has impacted the legal profession is a very interesting question, because I think when it all started in March, I could see despair everywhere, including myself. No one was prepared for this. There was an absolute hold on any new work coming in. There was an absolute hold on the continuing work getting continued. There was an absolute hold on your invoices getting cleared. So everyone was thinking, where's the world going? The crude fact remains that yes, people have been impacted. Our profession has been impacted. But again, why I love lawyering so much is that there is always a way out of any situation, like in a case. So we for one, we as a firm decided that there's no point sitting and brooding. Let's do something productive in this time. So we researched and we created research wings and we created, teams which were researching in specific areas of law: arbitration, data protection, insolvency, insurance. And I think now, 3 months down the line, looking back, we didn't feel that we were out of work for some time, and the work started coming in again. The world, kind of balanced itself, made sure we're humans. We kind of find a way out of everything, and it's as good as it was pre-COVID. We feel we're kind of busier than prior to COVID.
Thank you for instilling hope in us, Sameer, and that in future of law. And so I personally think you've always been ahead of the curve. Like you mentioned, you've already used AI for your arbitration. And some while ago, I saw PSL was looking for an innovation and knowledge associate, which was quite interesting to see. So what are your other future plans for your firm?
So, yes, knowledge and innovation. It was an idea which came to all of our minds during COVID, and how technologies will be assisting all of us. We decided to, kind of develop in-house technologies which would assist us in workflow management, which would assist us in better interaction with our clients, more transparency in terms of work. It just gave us a lot of free mind space to think of more innovative things which we can do in the profession of law. I think the whole notion of that law is an archaic profession where you cannot really innovate is something which we want to crack. That's why this department, we have hired one resource very recently. The idea is to constantly look for newer technologies. We're thinking of incubating tech guys who can develop applications. We're in the process of developing a portal and an app for use by our clients and internally for a lot of other things. You'll shortly get to know when we announce it. So our future plan is to be, one firm which provides very cutting edge technology assisted services to our clients. As I'd already said, as far as the disputes team is concerned, we would focus more on in-house advocacy. My idea of this firm is to be one where we churn out maximum number of senior counsels, ASGs out of here. Appears to be wishful thinking for now, but that's how aligned everyone in the firm is in terms of the future. Do good matters, but do them well. That's the motto. We don't want to flood ourselves with any and everything, because then we won't do justice to any of them.
Godspeed to that, Sameer. And speaking of future, let's come back to the current times and see how the environment is for lawyers and fresh graduates. What would be your advice, for lawyers who want to pursue their LLM right now or considering to do that in future?
I always tell students that while it's a great idea to do an LLM, but always try doing that once you've had some experience in the industry. I've seen a lot of students finishing their 3 years or 5 years of law school and immediately going abroad to do an LLM. For me, it's just an extension of your law school. So rather than 3 or 5, you're finishing a graduation in 4 or 6 years, which does not give you a practical experience, which is just another study course for everyone. And so what I advise them is that come in the market, work for 2-3 years, see what you like to do. You may want to do tax when you were in college, but 3 years down the line, you realize, oh, tax is just too complicated for me. I want to do, say, arbitration, or I want to do, say, criminal law. And once you have set your mind on one area, seen the nuances of that particular area in practice, you will be able to appreciate your LLM course much better then. So if you're doing an LLM, if you're investing a lot of money, make it count. That's what I believe in terms of doing LLMs. To fresh graduates, I know the situation is kind of unstable right now. There are lesser opportunities. A lot of firms have hiring freezes. But from where I assess, the situation is going to improve, and it will improve for the better. The situation will be better than what they were pre-COVID, because a lot of reorganization will happen on the corporate side. A lot of renegotiations will happen on the corporate side. On dispute side, as you know, a lot of disputes will come. So the amount of work will increase. Maybe luxury litigation will reduce. I know for a fact that most corporates are now reducing their litigation budgets. They're reducing their legal budgets. So there'll be more work, lesser fee, but just wait it out. The key to survive this pandemic is to stay positive and wait it out. It's just a couple of months out of your life. Life is very long. You don't have to fret about things. The world's not ending.
That's true. Very sound advice.
Yeah.
Very sound advice indeed, Sameer. And generally, what would you say is the bent of mind of law firms while seeing applicants with LLM from India and from foreign universities? Any thoughts on that?
Everyone has a different choice to make. There is, yes, some difference between LLMs in India and LLMs abroad. I personally think LLMs in a couple of colleges abroad is really an extensive course, which also helps you to make a lot of connections with people, relationships with people. Your vision gets more global. That, of course, is a problem when you do an LLM from India. But it depends on the objective on why you want to do an LLM. If your objective is solely to expand your knowledge in a particular area of law, then if an Indian college is good in a particular area of masters in law, then why not go there? While if you think that, say, a disputes course or an international law course or a IP course is better abroad, go there. However, if your objective is to, better your perspective in terms of this whole global legal profession, choose abroad. But again, you need to first sit down and think, why do I want to do an LLM? Do I want to do an LLM only to show it on my CV? Let me tell you, from a recruiter's perspective, really doesn't matter. But you may get an interview with an LLM on your CV, but if you don't really have that knowledge when you are interviewing with your recruiter, it doesn't really help. So it all depends. There's no straitjacket answer to this.
So your preference is somebody who's actually done the work in the courts and comes with, that's a better CV point than actually taking degrees.
I would always want to see someone do an LLM after they have actually slogged it out in the real world.
Fair point. So Sam, we've reached the end of our interview, and as a parting note, would you please share a success mantra for our lawyers?
Too young to say that, but also I think, but passion is the key. And that's a success mantra, not only for lawyers, but anything that you do in life. If you were to do law only just because it's your bread earning mechanism, no. You need to love what you do. If you love what you do, then you enjoy what you do. And once you start enjoying it, then there is no way that anyone can stop you from being successful. And when I say successful, it doesn't mean that you need to earn cross and cross. I think a good matter, a good relief in the court, a good outcome of a negotiation would give you a better high than anything else in that world. So the idea is to be in love with what you do. And specifically in the area of law, because I think it's a very, very demanding profession. Once a client comes to you and gives you a brief, you take all the tensions, worries away from that client and get it on your head. So you're carrying your own burden, you're carrying your client's burden, and not one, maybe multiple clients. So it's imperative that you really give it your best. There are some matters that by the time they end, they take a small part of your life away. You should be able to sacrifice that. You should be willing to sacrifice that, and you'll be only willing to sacrifice it only if you love giving that part of it. So I may sound very philosophical on this, but that's what I believe from within that. If you're not in love with law, rethink about it.
I agree with you, Sam. That's actually true. And thank you so much for sharing your valuable views with us, Sameer. I am sure our viewers would learned a lot from you today. It was an absolute joy speaking with you, and thank you so much for your time.
Likewise for your time, and it was an absolute pleasure.
Thanks, Sam.
Thank
Bye-bye.
you. Bye.